Locking horns with the CFPB or any state regulatory body is certainly not something any new or existing mortgage company wants to do. Now, while every company should strive to be on target with their compliance program, at some point in time, you will be faced with an audit on either a state or federal level. Now, one thing for you to know is that as of May of 2022, the state authorities were given federal audit authority by the CFPB. Now, this means that both the CFPB and the states are able to and will conduct exams or other supervisory activities at your organization. So what can a company expect from what the CFPB calls a supervisory relationship with the CFPB? Well, under the Consumer Financial Protection Act of 2010, the CFPB conducts supervisory activities for the purposes of assessing compliance with federal consumer financial law and also obtaining information about a supervised institution's activities and compliance systems and procedures, and then lastly, detecting and assessing risks to consumers and to markets for consumer financial products and services. Now, supervisory activities may help entities identify issues before they become systemic or cause significant harm to consumers. So effective supervision depends on the cooperation of the company's staff with the examiner's request for information, a collaborative relationship, and a clear communication on both sides. The CFPB supervisory activities are confidential, promoting candid communication between supervised entities and the CFPB. So that being said, you should be aware that the CFPB implements what they call risk-based supervision through a prioritization approach to allocating supervisory resources. Now, the prioritization process is how supervision determines which consumer financial markets and which entities in them are at risk to consumers. Now, as you can see in the chart, the CFPB supervision operates as a continuous cycle that looks like this. When conducting an examination, CFPB's examiners generally do the following: collect and review available information from within the CFPB, other federal and state agencies, and public sources consistent with statutory requirements. They review documents and information obtained through information requests sent to supervised entities. They also conduct on-site or virtual portions of an exam to observe, conduct interviews, review additional documents and information, transaction test, and assess compliance management. Consulting with the CFPB on legal issues arising from an examination, including legal violations, is the next step. Then they draw preliminary conclusions about the regulated entity's compliance management and its statutory and regulatory compliance after internal consultation. Then a consult within the CFPB about examination work product and any corrective actions that institution should take. And then lastly, send the supervisory communication to the supervised entity. Now, examiners use the Supervision and Examination Manual, which, by the way, consists of a ridiculously overdone 1,800 plus page manual. Now, this is their main resource in conducting examinations and other supervisory activities. While supervised institutions are bound by statutes and regulations and not by the Supervision Examination Manual, the CFPB makes them publicly available as a resource. Now, among other topics, it includes background information about relevant statutes and regulations. And by the way, they have a convenient disclaimer attached to the manual that states that the manual should not be relied on as a legal reference. Legal discussions in the exam manual are not binding on examiners or other CFPB staff. They go on to say that a supervisory finding that an institution has violated the law is based on an application of the governing statute and regulations to the institution. So the manual is only a starting point for identifying a potential violation, and if that doesn't scare you, then you've got ice in your veins. Now, in case you're wondering about what happens at the end of an exam or other supervisory activities, the CFPB website states that the examiners will provide supervised institutions with their findings in a supervisory communication, such as an exam report or a supervisory letter. Now, exam findings may include matters requiring attention, or what they call MRAs. Now, examiners use MRAs to communicate specific goals to accomplish or address violations of law, risk of such violations, or compliance management deficiencies. Now, their website even provides a friendly little reminder that just as they have established a strong relationship with many existing supervised institutions, that they look forward to establishing new productive supervisory relationships with those that they examine for the first time. Now, as far as relationships go, this is one you'll eventually be in whether you like it or not. Now, if you've watched this video to the end, you should know that there are 18 different federal laws that fall under the Federal Consumer Protection Act that mortgage companies, whether you're a broker or lender, should be covering in training to all of their staff depending on specific duties. If you don't currently have a training program in place as part of your compliance management program, you should reach out and we'll give you a hand. Best of luck. We're here when you need us. Just make sure you're covering all your bases now versus needing us in the face of an audit when it's too late. I'm Uncle Aaron, and I'm out.